Okay, everyone, welcome to the Orangeville Police Services Board. Today, it's September 19th. I guess I'll call this meeting to order, and we are a little bit late here at 4:11. Call the meeting to order. So I guess first of all, I would like to congratulate, not welcome, because our new inspector isn't here, but we have a new inspector of the Orangeville Police Detachment, and that is Mike DePasquale. And so I think I'll save the introductions for him for when he is actually here in person. And then the other thing that I would like to do, and we're excited to share this information, is that our board member, member Ian McSweeney, has received an award, and he has received the King's Counsel designation. And the King's Counsel designation, for those that don't know, it's given to lawyers who have demonstrated a commitment to the pursuit of legal excellence in the service to the Crown, the public, and their communities. And just as a side, we know that to be the case about the community piece, just based on the tremendous work and the many things that you're involved in. So kudos to you, my friend, on that award. That's quite the honor. Anyway, amazing. So why don't we move on to item 2, which is disclosures of direct or indirect pecuniary interest. Does anyone have anything to declare for this meeting? No, seeing none, we'll move on to item 3, which is the approval of the agenda. Can I have a motion to do so? Mayor Post.
Chair, just have one.
Okay.
I'll get it eventually.
There we go. So you have an agenda change?
Yeah, so I just wanted to add under the new business category, the mandatory police training and review of the new regulations under the new legislation. I'll just speak very briefly to that.
Okay. And I would like to add as well, item 6.9, and we'll just call that the men's homeless shelter update. Okay. Madam Secretary, are you okay? Good to go? Okay, so we need a vote to do that. Thank you very much. So a vote to change and amend the agenda. Member McSweeney? Ken, in favor? All in favor? Yes. So we're into our public session, and we're going to have the OPP report at this time. So we do have Acting Inspector Dean Korn here with us, and a status update is item 6.1 on the OPP strategic plan. I guess it's just how are we progressing on the document? Are we anything further to being released or seeing, or how's that going?
Thank you, Mr. Chair. I made some inquiries on Friday. Short answer is it's not ready yet. However, I was told that it should be coming in within the next 4 to 6 weeks. That'll be both the OPP progress report and joining that to the Dufferin action plan. I guess from what I was told from headquarters, those two documents are linked along with every other detachment in the province, and those should be forthcoming.
Okay, got that. And I guess why it's important to us is this board spent a fair bit of time weighing in and going through the process on the Dufferin action plan. So we're just curious to see how that dovetails with the OPP strategic plan and understanding what the priorities are going to be over the next couple of years.
I can tell you that I'm not sure if I mentioned this at the last meeting. I did review the draft that Inspector Ward, or now Superintendent Ward, put forward. And from my understanding, there was no amendments suggested from headquarters. So everything should be exactly as your input was with him.
Okay.
So, Mr. Chair, just as in terms of next steps, when that happens, that action plan will then become our business plan. So we will rename it to jibe with the way the regulations read, and then we'll adopt it. And then we'll add it to our governance materials.
Agreed, and that will tie to what the board will view as priorities or not. And if it's not on that action plan, then we won't do that.
I agree, but I think in the past, we have always been open to keep a running list of new items.
Fair.
Whether they're for next year or more immediate, but you're right, it's a living document, I think.
Fair. So that takes care of 6.1 and 6.2. Madam Secretary, will I receive each one as we go, or are we going to do it at the end? Receive 6 at the end. Is that okay? Okay. So item 6.3 is the community awareness issue, awareness initiative. Did you want to speak to that, or this is with the community partners and whatnot? I think, is this the letter?
This is the letter, yeah.
Okay. So I don't know that we need to read that. What happened at the last meeting is Acting Inspector Corn, we agreed on the letter that the board was going to send out to the community partners. And so the board is going to progress that and move forward with it. And it's just literally here for, I guess, your edification, right? But I assume you're still in favor with that?
Definitely, yes.
Okay. So then we move on to 6.4, and this is the Association of Municipalities of Ontario, AMO, and there was a traffic services option. There was a PDF document attached. This is on page 10 of our document, and it talked about the automated speed and traffic enforcement. I don't know, is this something that we would share with council and make a recommendation on this? How would the OPP feel about such a service? Do you have an opinion on such a matter?
I think typically the OPP does not get involved in the automated services within the municipalities. So I would leave that with your discretion, sir.
Okay, thank you. And so board members, would any board member like to speak to this item? Mayor Post?
I just wanted to provide a bit of an update to say that anything when it comes to automated speed enforcement has to be done through council first. Council has to make an agreement with the ministry on how that will move forward, and will have to fall into the regulations that are outlined for automated speed enforcement. So if this is something that we want to move forward, it would have to be done at a council level first. And we could take an endorsement of the Police Services Board if that's something we wanted to move forward, but then it would have to go to council for ratification and for the next steps to progress it.
So that's my question. Would the board like to send an email or a letter to council and request, or do you want to leave it?
I just wanted a clarification. So this is in one of the items in the delegation to the Attorney General from Mayor Creelman. So it kind of fits with what we talked about in camera that we'll be reporting on in open, but we're already preparing a letter in connection with that. So the two should be consistent.
So we can add that to it?
Yeah.
Okay. Okay. I think that's fine. Ken, are you okay with that suggestion? Yes.
Yes. Yes.
Okay, very good. So we'll leave 6.5 and we're on to item 6.6. And I guess it's just going to be a follow-up item as we go, Acting Inspector. And it's all about how did we progress on this over the summer? Usually the summer months are the most difficult. And we had citizens in here last time speaking to this and pleading passionately for enforcement and what the plan would be. And I think the main focus was modified mufflers and how we can help our community on that. Did you want to speak to that item?
Thank you, Mr. Chair. So when I went back to the detachment, relayed that concern to the traffic unit as well as the patrol side of the house. As a result, there was a focused patrol incident generated to deal with this. Officers laid a number of charges over the summer months. There was in excess of 40 charges throughout the summer for strictly noisy mufflers. There was some ancillary charges spun out of that as well on those traffic stops, but to address the actual noises, that's what our results are so far, and they're going to be continuing year round, not just the summer months.
Is there a plan to revitalize the, what was the catchphrase of the OPP plan? Do you remember it's not a fair question because neither of you were here, but Inspector Ward had a program that he ran, and does anybody remember what it was called?
Was that Noisemaker, or am I misunderstanding?
No, it's not the coffee related one. It was related to, there was some sort of operation to focus on noise. And it was a strategic imperative. It was done over a 3-week period, and that was the focus. And
I believe that was Operation Noisemaker.
Okay, and a PR campaign and whatnot that was associated with it.
Yes. So there's nothing stopping us from doing that again. I know with the summer months, they were focused mostly on just doing the enforcement versus the education piece, because I think we're beyond that now. People know what they're supposed to have on a vehicle for equipment, and some just choose to outright ignore that. There's nothing wrong with doing more public notice on that, just through social media platforms, et cetera. However, we are taking a firm stance on it.
Got it. A little off script, if I could. Citizens have contacted me personally about noises. And candidly, they're from Settlers Creek area, Sherwood Avenue. And if they see and hear an individual who is causing a disturbance with the vehicle, my response is the usual, and that is file a report with the OPP. That's first and foremost. Don't phone your local representative. Make sure you're doing that. But the questions came out, what if it's a small area over there. What if you know where this person lives and the issue? What can they do? I assume it's follow back up, give the address, that sort of thing. But do you have any counsel for the people in the West End, specifically Sherwood, regarding?
I think you nailed it, Mr. Chair. If they do have information, license plates, vehicle descriptions, addresses, because they know that's where the car lives, by all means, forward that same information. The more we have, the better. And that very much narrows things down for our people, is that if they see that particular vehicle, or if they know where a vehicle resides, then they can certainly look at those more often.
Okay. And candidly, I'm leading you here, but the OPP can't press charges unless they witness or see. They would just go and they would speak to the individual and share why this is
technically
appropriate behavior.
Yes, you're correct.
Okay.
There is an avenue for a private citizen to do an information at court, but that is a large endeavor for somebody. And I think for the matters of traffic like this, it would be far simpler and more satisfactory to the actual resident just to call us and let us deal with it from start to finish once they provide that information.
And are videos helpful or a hindrance?
Oh, anything is helpful. There's nothing ever wrong with that.
Okay, very good. I will follow up, and I can't imagine them watching our exciting video here, but I will follow up with the individuals as well and share that. Okay, so item 6.7 is officers in school. I was quite pleased to read that there has been some progress on this file, right? So you've got a new school liaison, and there's some other initiatives that are ongoing beneath this. Did you want to speak to this item and tell us what the updates are?
Yes, we are very pleased to announce that Constable Amy Pitton has been the successful candidate to go into our school liaison position. We further have reached out and have a meeting scheduled on September 26th with the district school board, and at which time the superintendents of the schools are going to be there. We're going to flesh out exactly what their expectations are and come up to some sort of mutual agreement on what our role will be with the schools. Not to be confused with us putting officers back into a full-time school liaison position in the school, but some sort of mutually beneficial arrangement that we will have officers that are available to the schools to deal with school and student issues.
Great. Board members, any questions?
Yeah, so that's a great initiative, and it's a start. I mean, whether it's the thin edge or the wedge that leads to something more will be determined in time. But that's a terrific start. The dialogue is obviously resumed, and a program that was, I will say, summarily dismissed at one point is now back on the agenda for a second look. That's terrific. So.
And board members, just as a follow-up, I was asked to contact our education trustee, which I did do, and he was not able to join us for this meeting, but he will join us for our next one and speak to the item. So,
sorry, Mr. Chair, I would like to, was wondering if we could have this constable come out and speak to us too as a board, maybe down the road. Like to hear her priorities, hear what she's doing and seeing in the schools.
Be great. Yeah, the acting inspector has agreed to do that, so we'll schedule that. Good. Okay. So item 6.8, it's the digital process for vulnerable sector checks. Mayor Post, it was your communication that I think sparked this. Did you want to give a little bit of background before am I putting in a spot? I don't mean to. Yeah.
Yeah, no problem. I had heard from a couple of residents, one in particular who was concerned about having the only option to do vulnerable sector checks as being online, and was hoping to find a location nearby that was still offering an in-person service. I learned at that time from Inspector Corrin that the process has changed and that it will be shifting completely online going forward.
Inspector Corrin, did you want to speak to that at all?
Just that I think that there was some concern about some public access with regard to those online checks. And with the Triton Canada is the organization that's responsible for those, they have made it available through a toll-free number, 1-833 number, as well as that you can access that, or an individual can access that from the public library, et cetera, to actually use the computer to do so if they have no access at home.
And highly secure, and
there have been zero concerns or anything brought forward to suggest that there's been any breach of any personal information.
Okay. If I may, I also think if I was on council, and I know I'm wearing a different hat today, I'm on the Police Services Board, I would be wondering what is the implications for this from a financial perspective. And the way it's set up is that we would no longer receive those revenues from these items. However, there's savings that'll be found within the OPP. You're looking at me perplexed, but that's what was in the report. So I don't know that you need to report on it. We're certainly not going to push it or ask for anything here. We assume the OPP would follow through and we'd be revenue neutral.
That's my understanding. The only perplexion I had was just with regard to the local detachments were told as this was happening, there was no consultation process. And that's not a criticism. It was just that this was a new procedure that we were starting to adopt. And yes, it does free up resources at our detachments that would normally have been, or up until now, have been dealing with the walk-in face-to-face.
Got it. Okay. Any other questions from board members?
Just wanted to add a 6.9. A couple of days ago, Mayor Post.
You're going to talk to 6.9 now, or we're going to talk to 6.8? So we're leaving 6.8? So you're good on.
Sorry, I'm out of turn. I thought.
Yeah, you're good on the vulnerable sector checks.
I will stand down for 30 seconds.
Okay, so that's fine. So you want to talk to the ad, which is 6.9, and then it's the men's shelter.
No, it's Sea-Line Construction on the impact.
So is that 6.10?
What, have you added 6.9?
We did. We added 6.9 was men's homeless shelter, right? No?
Yes.
Are you adding something else?
I've just in error numbered mine 6.9, so mine will be 6.10.
Okay, let's go to 6.9, which is men's homeless shelter.
Nobody expected the Three Stooges to arrive.
I know, exactly. So I just think it's important if there are people online, and I did tell people that this would be discussed in the meeting, and we were going to talk about the men's homeless shelter. The Police Services Board met in closed doors, updated on what's happening with the men's homeless shelter, and I guess the concerns that the community has that are seeing what's going on with the men's homeless shelter. So the board is updated. I think the citizens are updated on what the issues are. The OPP are here. I would preface this as the OPP are aware of what's happening in that area. You're highly focused on what the issues are, and mitigation strategies are in place. And I would assume that you don't want to speak to what your tactics and plans are in a public forum, but I'll leave that to you to speak to.
I don't want to sound redundant or anything like that. However, if there is an issue, please call. I mean, if a resident has a concern about something taking place right then, right away, call the non-emergency number, unless it's urgent, and then by all means call 911, and we will certainly attend regardless.
That's great. But just to be upfront in this forum, you are getting significant calls and concerns from the community.
We have been made aware, yes.
Council is getting significant concerns and calls from the community. And the point of it is the OPP are on this. They're very involved in that area. And that's all the point that I wanted to make. And I'm not asking what your mitigation strategy is. I'm just stating that the public should feel confident that this is being looked after.
It is.
Great. board members, does anybody want to speak to this item? No? Okay. I guess we'll go to item 6.9, and my apologies for the confusion, Member McSweeney. Did you want to speak to?
Yeah, no, that's fine. So it's just the construction community safety issue email that Mayor Post circulated. And I think Inspector Corn, you're aware of this. Complaints from some of the residents about the impact of construction on Sea Line in between Brenda and Diane. It's just a receiving item, I think.
Yeah.
The information's been communicated to the OPP, and we'll hear a report when a report is available.
I think that's great. And if I may, the other one is Veterans Way. And there is construction going on in that area, and there was concerns about speeding construction vehicles and what's happening in that area. Did you want to speak at all on those two items, or?
Just that in both of those locations, this is not giving away anything here, but it's a great location for the Black Cat to be deployed. Our traffic unit is aware of the concern. I relayed that the day I received the message on that to make them aware. They will deploy those as they see fit, and they will conduct enforcement just to be visible, if nothing else, and to conduct any sort of corrective measures need to be taken for what they deserve.
Okay, great. I know staff and council will be reviewing traffic calming measures as we progress in certain council meetings regarding these areas. The only other one that I just wanted to bring out, and I did not prep you for this, Inspector Corn, but it's just Preston and Parkinson, so same thing. And the first comment we talked about was about trucks speeding. This other one is just about the general makeup of those streets, and there's a desire for traffic calming measures in that area, and the speed is of concern. So I just bring that to your attention in a public forum, and do what you wish with that, but the people that are living in that area are concerned about what's happening. Preston and Parkinson. Yeah. Okay, any other thoughts, board members, for Inspector Corn? Yes. Did we? Thank you. Who's running this meeting? I'm sorry. So 6.5 is the MCRT. It's the mental health, the expansion and continuation of services. And in my notes here, Mayor Post is leading a meeting with the minister, and it's talking about the expansion of mobile clinics. And then what the conversation was overall was expanding the MCRT coverage of the additional availability during the week and on weekends. Mayor Post, did you want to add anything to that? Or? Sure. Okay.
The only thing that I would add to that at this point is that I'm still in discussions with the ministry, trying to choose a date to have a roundtable discussion with all of our community partners in regards to just overall kind of general mental health services within the community. And when it comes to the MCERT team, when we did our delegation to Minister Thibodeau at the Association of Municipalities of Ontario conference, we did let him know as part of it that we wanted to work with him and SolGen to expand those services, to look for additional funding. We talked about the success of the project, how well it's working in our community, and the desire and need from our health partners, but also from our police partners, to expand the program to make sure we had additional coverage, specifically on weekends and evenings. As we know, crises don't often happen Monday to Friday, 9 to 5. And he was very supportive of that idea and ensuring that when we have our roundtable discussion with our community partners, and we can all get together at one table, that we can talk about how we can better work together to make sure that we're giving wraparound services to the people who need it the most.
That's great. And Inspector Corn, I don't want to put words in your mouth, but based on the emails, you're very supportive of these initiatives as well.
Absolutely. And I would just like to add that I wonder if your conversation sparked some sort of support, because the OPP just put out on our internal bulletin board a topic about the MCERT and how they hope to expand it across the province and all locations and make it a full-time, round-the-clock, 7-day-a-week situation. So I don't know if it's coincidental in the timing, but regardless, the support is there. So I think moving forward, it's going to turn out well.
Oh, that's great. Okay. Inspector Corner, is there anything else you'd like to add? And if I could also just preface, did you want to introduce your new team member while you're here as well?
Yes, thank you very much. I was hoping to have an opportunity. For some of you that know newly transferred and newly promoted Staff Sergeant Corey Chawartha, we welcome her to the Dufferin team. I mean, I worked with Corey in Wellington, her former position, and as I go back in 2 weeks, I won't be seeing her as much anymore, so I'll miss her, but it's our loss is your gain. And I know Corey started off in this area and in the Caledon area as well, so I think her coming back to this is great for your community. So
it's great. I don't know if people know, but you're an Orangevillian. And I think all of us have known you for a long time, so we're super excited to have you here. That's just great. Thank you for being here. We'll make sure, board members, if you could duly note that we would like tough questions for our new staff sergeant at the next board meeting, that would be great. Anything further that you'd like to add, Inspector?
If I can have your indulgence just for a second, sir. I know there's been some ongoing concerns with Highway 10 coming through the area, some traffic concerns. We just last week, I implemented an initiative. We partnered with Caledon Detachment and Grey Bruce Detachment and did a 2-day traffic initiative on the entire length of Highway 10 from Mayfield Road at the top of Brampton to Owen Sound at the termination of that highway. We included a lot of officers from both us in Dufferin here, Caledon and Grey Bruce. I just want to touch on some of the numbers we got. There was 525 Part 1 offenses issued. The bulk of those were for speeding. We also issued 79 warnings for a variety of offenses. There were 16 criminal code charges laid, including 4 impaireds. And interestingly, it demonstrates that drinking and driving occurs and drug use and driving occur at all times of the day because this initiative actually focused during the daylight hours. There was a handgun seized after a traffic stop, along with a significant drug seizure and a significant amount of cash that was seized as proceeds of crime as well. So all in all, that was in 2 days, I think a very significant amount of charges. There was a third day added as well where the focus was on commercial motor vehicles. There were a total of 50 trucks, heavy trucks that were stopped and inspected. Of that, 25% of those were placed out of service for a variety of safety defects. So we had great success, but in saying that was successful, I'm a little discouraged because those numbers are far too high for what should be a roadway that's a safe one to use for everybody. So it, if nothing else, it illustrated the need for constant enforcement by all 3 counties and just to make sure that people can travel to and from safely. So we're going to keep focusing on that as well as all of our other responsibilities. But I think you can count on this being a regular, at least annual or biannual event that we will do that type of enforcement initiative because 10 is far too important to use for people than to have it being used dangerously by a select number or few people.
That's amazing. I know Mayor Post has been very involved with Mayor Creelman of Mono and trying to improve the safety of that road. And we're certainly grateful for all the efforts of you and your team. So that's excellent. Post, just for fun, did you want to speak to that? Because I know it's been near and dear to you.
If you don't mind, that would be great, Mr. Chair. I just wanted to add that we're happy to receive the information from the Ministry of Transportation that they will also be studying that length of road all the way through to the end, the northernmost point of Dufferin County. They are doing it in 2 phases, starting with with our southern partners in Caledon, starting at the north point of Brampton all the way to the southernmost point of Orangeville. And then the second piece will include the portion that goes through Orangeville and through the rest of Dufferin County. So they will be looking for additional safety information as well as traffic counts and updating some of those pieces to make sure that they can put in additional safety measures in that area as well. So it's great to hear that there's lots of enforcement to back that up as well. Thank you.
That's great. Okay. Thank you, everyone.
So, Mr. Chair, I know that it's a resource question, but additional enforcement would presumably eventually lead to less infractions. But it's a question of cost. So, I mean, is there a number that you're angling at to kind of start seeing that dip in incidences?
I don't know if I can answer that without a lot more data. And I would need to see some historical data as well from multiple initiatives to start to build on this to see if we are making a difference or not. That is just a brief snapshot with making decisions in a vacuum almost. I would like to see this done more often, balancing the fact that if it becomes so regular, then the results may not be realistic. People slowing down only because they see black and whites out there doing that type of high saturated enforcement versus the daily enforcement that I'm not sure what other term to use that we would typically do out there. Does that make sense?
Oh, it does. I mean, it's difficult to deter with limited resources, and what you really need to do is a longer term project of educating people and deterring crime at its root, as opposed to when it gets transported from A to B.
That's great. Okay, board members, any further questions or comments? OPP, any? No? Okay. Can we have a motion to receive, I guess it would be items 6 all the way through, and we added 9 and 10. So 6, 10, post, 10, thank you. All in favor? Yes. Okay, thank you very much, everyone. So we'll move on to item 7, which is the grant update. Item 7.1, which is on page 35 in your document. It just speaks to the email notification that we've received payment for the RIDE grant. And I was just curious, Inspector Corn, did you want to speak to this and talk about what the money would mean to the detachment, or is that, do you want to offer anything or no? That's fine.
Nothing in particular, Mr. Chair. The RIDE grants are always good for us as well as the community. For us, it allows us to do bring in officers on extra shifts and overtime to do a focused RIDE programs and RIDE checkpoints. So anything that we can get as far as a grant is always well received and appreciated. So that would be my only input to that, sir.
That's great. Thank you, sir. So I guess we'll need a motion to receive. Actually, why don't we do 7 at the end as well? We'll do them all at once. We'll move on to item 7.2. And this is the Mobile Crisis Response Team, the MCRT Enhancement Grant. And at this time, there's no news in our application. However, all of the data has gone off. So there's nothing else to share as we are. I'm curious, and Mayor Post, I don't want to set you up for something if you're not comfortable. Know that you were involved. Well, did you want to give any information, or is it just you're good with this at this time? And yeah, okay. Okay, very good. I guess where I'm going with that, if you're the public watching at home, and that is that Mayor Post has advocated very strongly to ensure that we got to this point and was able to continue with the program. And our board secretary, Mary Lou Archer, has been instrumental in helping and leading filing for these grants. So it's a great team effort on that. So that's 7.2. And that leads us to 7.3, and this is the bail compliance and warrant apprehension grant. I guess board members, if you have any commentary on it, I don't know that you would. I think it's fairly straightforward, but either we comment or just we'll receive it. Commentary, Ken, you're good? Okay. And item 7.4 is the grant application guide. So really it was the dates, timelines of submissions and whatnot. And Member McSweeney, did you want to make a few comments on 7 point?
Yeah, we've been talking about this for a little while. The thought was that we would institutionalize Mary Lou's expertise on the grant application process for future boards by putting together a little guideline for the grant approval process. And that way, we don't expect to lose Mary Lou anytime soon, but that way we'll have something in writing that will act as a guide as we go forward to help us with the grant process.
And that's where the times and key dates and whatnot.
All of that stuff. And we will be preparing, Mary Lou and I are going to be preparing that, and we'll bring it to the board as soon as it's available.
Okay, very good. Board members, any further comments on the items that are in subset 7? No, seeing none. OPP, just as a courtesy, any further comments on section 7?
No, sir.
None. Okay. Can I have a motion to receive sections 7.1 to 7.4? Ken, thank you. Member McSweeney, thank you. All in favor? Yes. Okay. So this is item 8, and it's on page 38 in your documentation. And this just speaks to our commitment to each other in terms of service standards. And the service standards are simply key dates and timelines that must be met in order to progress through each meeting and make sure that we are following up on the deliverables that we committed to each other that we would do. In my humble opinion, we followed that process again. And I guess before I bring to a vote, just an aside without details, I'd like to thank you, Mary Lou, for your work. And I know you had some personal things going on, and we still managed to deliver all of those things given your unique circumstances, and it's not unnoticed. So we greatly appreciate you and the work that you do. So thank you. Board members, would anybody like to speak to item 8? No? Okay. Can we have a motion to receive item 8? Member McSweeney, Member Post, all in favor? Yes. Okay, thank you, everyone. That's item 9, and item 9 is simply the board member claims for special remuneration. And this is any kind of meetings that happen outside of this meeting, tasks that the board has ongoing, that sort of thing. And there is some special meeting assignments that were here, and those claims are attached for anyone to read, including the public, and understand why these monies are being issued, and the long list of the key dates and whatnot. Is there any questions from any board members regarding these charges? No. Seeing none, can I have a motion to receive this item and approve? Thank you. Member McSweeney, Mayor Post, all in favor? Thank you, everyone. And that brings us to item 10. Item 10 is the Zone 5 summary. So there was a meeting September 12th, 2023, and all the follow-ups that were involved. Member McSweeney, before I turn it over to you, you are a representative at these meetings, and I think there was some conversation in here about training that I'd be interested in just hearing a little bit more about. Provincial appointments, which we'll get to, but I know there was a discussion in there. And then I guess the usual, and that is much for Representative Zone 5, and I'll turn it to you.
Anytime I get to travel to Guelph, I'm always happy
Yes.
to. But it's true. The Guelph police have a brand new station that's taken quite some time to construct, and it is a beauty. Lots of room for expansion, and they're very proud of it. So I think they'll be hosting the in-person Zone 5 meetings for a time. They've certainly offered that. So I will just be brief, and just to refresh members of the public's memory. Zone 5, the Ontario Association of Police Services Boards is divided into zones, and each zone covers a different region within Ontario. Our region is Zone 5. There's 6 or 7 boards within Zone 5, and we get together periodically to meet and discuss things of common interest. And so at this particular meeting, it was interesting. The guest speaker was Lynn Haves, I think is the right pronunciation of her name, and she's the acting Inspector General of Policing. She was there as a substitute for Mike, I got this right, Mike Teschner, who is the actual Inspector General of Policing, and he's on a leave of absence till the end of the month. So she was just giving a brief rule. The Inspectorate General, it's a sort of a new entity under the new legislation, and it does a number of new things. It's modeled after a model that derives out of the UK, And it will be replacing things like the CPSA in terms of investigations and complaint review and the like. But it's more encompassing than that. And so they're very much looking forward to that new challenge. I had actually met with, so his name's Ryan Teschner, and Dwayne Sprague a couple of times about our governance initiative. And I find Ryan used to be on the Toronto Police Services Board. He's the perfect appointee for that position as Inspector General. And he is very much dedicated to governance. So he will be a good ally going forward with respect to implementing the changes required under the new legislation. So Dwayne Sprague, our ministry representative, gave the usual update on the legislation, and there was actually a bit of good news. Unlike, I think, the previous meeting, the best estimate for the new legislation coming in was June or July of 2024. It now looks like it's April of 2024, whether it's the beginning of April or the end, they weren't quite sure. But what that means is they've actually made progress on dealing with the regulations under the legislation, because that was the holdup. They didn't want to bring the legislation into force before all the details and the underpinning regulations were ready. So they anticipate that all of that will be done sometime in April. So there was, the usual, there was an OAPSB report, nothing really new there. There was some discussion from the OAPSB about the rollout of the new Police Service Board training modules. There are 8 individuals that have been selected to act as guinea pigs for these new modules. They're saying that they'll take about anywhere from 4 to 8 hours to complete. I'm one of the guinea pigs, and we had our first meeting just last week, and it was really just an introductory rollout meeting. We planned on next steps for the next couple of months, but quite quickly, and probably by the beginning of the new year, they hope to be in a position where they've got the training modules up and drafted, and the guinea pigs have been exposed to them, so that they will have ironed out most of the bugs, and then they'll be released on a broader basis.
All online.
It'll all be online, and for anyone that's taken these kinds of training modules, they're quite common in government. It's sort of a progressive model. So you go through a training, a subset, like the model may contain 5 parts, for example. And part 1, there'll be a presentation, then there'll be a series of questions, and then you'll score answers. And if you don't score enough right answers, it will take you back into the module, and you'll repeat it until you get it a passing grade. So by the end, it has the advantage of, by repetition, training you to get the right answers, which enforces memory, but also nobody fails, right? You just keep going and going and going until you've successfully passed. So one of the things that I advocated at that first meeting was there also should be some emphasis within the training program to boards being more responsible for proactive internal training themselves, and not just rely on the OAPSB. Or in this case, this will be the ministry mandatory training. Rely on the ministry to roll it out, and that comment was taken, and we'll see what happens with it. But I truly believe that most of the comments from people at the Zone 5 meeting were from police services boards that were saying things like, what do we do about training? We're not getting trained now. We haven't even been trained under the existing legislation and regulations. And good point. But there's lots of reasons why they're asking those questions, because they don't maybe really have a good grasp on what it is that they should be doing. But part of what every board should be responsible for is making sure that its members are trained either by internal processes or by reaching out themselves to make sure that there's adequate training. Dwayne never refuses any training opportunity, as you know.
So I find that a little bit confusing. What courses are they offering? Who are they referring to?
Well, under the current legislation, training is not mandatory. It is voluntary. And so what Dwayne does, he goes around
Oh,
to boards and suggests,
okay. So
Training.
we've done.
we've had that,
We've-
but
we've
that's
done.
because we reached out and
Yeah.
asked for it.
There isn't another course that we should have been.
No.
No. Okay. That's
No.
where I was going.
No,
So
no.
we're good.
So we're
Mr.
good. So as part of the new legislation, the training will be mandatory. And then in addition to that, I think the OAPSB is looking at what other voluntary training programs it might roll out. But this first set of modules will be the mandatory training that they're kind of engineering through the OAPSB.
Are you going to talk to the provincial appointments in your update or no?
I
Mr. Chair.
can. So the other part of sort of Ken, were you trying to ask a question?
Yeah.
Oh,
I just
sorry,
wanted
Ken.
to make a note that as a provincial appointee, we did have mandatory training online. Me and Member Rose, when she was on, we did have to take it with the province under the current legislation.
Right. So yeah. So it's for provincial appointees, it is mandatory, but for the non-provincial appointees of boards, currently it's not, but it will be. Yeah, so the final piece, there was quite a bit of time during the zone meeting that was taken up by a discussion on where are we at in terms of the government's announcement, and I think it was sometime, about more than a year ago, announcement that they were reviewing the OPP detachments within Ontario and looking at consolidating the detachment boards. And there was a call in that letter, and I think Sylvia Jones was the minister at the time. There was a call in that letter, a reach out to municipalities, a reach out to police services boards for input with respect to how that consolidation should take place. And as a result of that, there was lots of input, I think, given sometimes from boards, sometimes from municipalities. And then it kind of, disappeared a little bit within the government. But, recently, some boards were advised earlier than others about what the results of the decision was. But I think they're working towards, if they haven't already achieved it, complete communication out to the boards with the result of those consolidation decisions. Orangeville has received its, as have the other police service boards within Dufferin County, and the results are in. So we are, the broad stroke of that is that we are going from 8 police services boards within Dufferin County down to 4, but those boards will be bigger.
Have you seen that, Inspector? Yeah, you have. And so do you feel great that you're leaving now just as we shrink your business in half? Because you used to do 8, now you only have to do 4?
As I head back to Wellington where they have 1,
Yeah,
it'll be an improvement for sure.
Yeah, I think it makes a lot of sense.
yeah,
personally.
it does.
Is that the end of your
That's the
report?
end of my Zone 5 report.
Very good. Thank you. Board members, any questions for Member McSweeney? No? Okay. Thank you very much for that, Ian. Appreciate it. So this brings us to item 11. Ian, oh, thank you. Yep, we have a motion to receive that report from Member McSweeney. Member Post, Ken, thank you. All in favor? Yes. Thank you, Mary Lou. Appreciate that. So item 11, this is the action register update. It's on page 72, and it really does speak to a lot of the items that we have ongoing as a board. And so policies, minutes, the website. I think the policies are actually going to be discussed in item 12, which is coming up. The website's going to be discussed in item 13. And then your presentation to council as well. We're going to do that in section 12 as well. So I think this document is just literally a show of all of the different things that we have ongoing and the progress reports that we have within it. Board members, does anybody want to speak to that, or are we just good to receive this item?
I'd just like to say something. And we'll get to this when we talk about our new governance structure. But part of that new governance structure will be service standards. Part of those service standards will be a work plan. I'm not sure how all of this will integrate back into the action register, but I suspect that we will preserve both. The action register will be preserved to deal with projects outside of the four corners of what's going on within the policies and our service standards. And yet our work plan will be that plan that will govern how we get to all of the things that we need to get to comply with our policies. So I think the need for both will continue.
I agree. And it's great to show the progress that we're making as a group. Okay, board members, any questions, concerns? No? Okay, can we have a motion to receive item 11, please? Ken, Mayor Post, thank you. All in favor? Yes. Okay, so item 12, and what happened recently is there was a great presentation done by Member McSweeney to Town Council, talked about all of the different things that we have ongoing as a group in terms of policies and how we interact with council. And I think, Member McSweeney, there is next steps to be done in terms of the linkage to council, and specifically prior to us doing that, there's next steps with the CAO and how we're going to go about implementing that. Did you want to speak to that item ever so? Like, I don't know how you're going to get through item 12 without, like, I think we just want a 2-minute summary of where we'd go because we've spent so much time on this, but I think it's the linkage.
Message received.
Yeah, but it's the linkage to next steps, I think, with council and the CAO that's important here so that the board knows where we're going and what's next, right?
Yep, I think so. So we put the next steps in the agenda. So the board today in this public session, in this segment, will be approving our new governance structure, which consists of a number of different documents, policies and bylaws and protocols and the like, all to comply with the new legislation. There are some things, once that approval occurs, we recognize that there are some aspects of it that require consultation with council in order to implement. So all of that has been built into these next steps. And in addition, as part of fine tuning the actual documents so that they're ready and polished to go after approval, we will take care of all of those steps in sort of in the sequence that I've outlined here. The next big step, of course, will be once we're done all of that, once we're happy with the existing structure of our governance system, we have to change it all because it all has to be revised and looked at in the context of the new Policing Act that's coming into force in April and all of the regulations that are coming into force at the same time. But that's okay, we've always known that, and we're in a much better position to do that now that we're satisfied that we're compliant with the current legislation and regulations, and that was the idea.
Board members, any questions on that? No? Okay. Motion to receive that report. Okay, thank you, and approve. Thank you, Ken. Mayor Post, all in favor? Yes. Okay. So item 13 is just a website update. Is Vice Chair McSweeney, you wanted to speak to this item as well?
Just very briefly. So we will be looking at the website again in the context of our new governance process, which emphasizes transparency. We will be, and a number of boards are doing this, we'll be looking at our information sharing protocols under our new governance policy with a view to trying to push as much of our documentation out onto our website as possible. So that the public can see our governance documents. They can see, in addition to our public meeting minutes, they can see, most of the stuff that we look at in order to discharge our day-to-day oversight role. I think other boards are doing the same thing. If you look at what other boards are currently doing, there's a huge range of from nothing in terms of what they publish on their websites to almost everything. And we want to make sure that we line ourselves up to that outer range where we're pretty much putting out everything.
Very good. Board members, any questions for Member McSweeney? No? Okay, we have a motion to receive that report. Ken, Mayor Post, all in favor? Thank you. So item 14 is the delegation to the Attorney General. And this is something that Mono's Mayor John Creelman did. There was a report that he put together, and candidly, it was quite good. It spoke to ways to make this system better, more efficient. There was some opportunities to offer a per diem for retired judges to speed up the process. There was a recommendation revolving increased fines and talked about probation orders as well. This was discussed in closed, and why it was discussed in closed is it just wasn't something that the board was entirely certain we wanted to share in the public session. The documentation is included in the open package, and it is included here in the open session so that the public could know exactly what was discussed. Board members, I tried to give just an overview there. Does anybody want to add to that overview before we pass on this, or are we just going to receive the item?
We can probably just
give a little more.
Well, we can probably disclose to the public that we intend to write a supporting letter.
Yes.
To the Attorney General supporting the initiatives that Mayor Creelman has described in his delegation. And just as far as context goes, one of those issues was Provincial Offences Act fines. And the problem with the current system and the amount of money left on the table because of the delays in the provincial court system and justice of the peace systems in actually working those things through the system to result in collectible fines versus individuals' constitutional right for a speedy trial, which was for a while kicking out all of these things because they weren't getting to them in time. The last time the OAPSB did a study on this, there was $10 billion on the table. I got that right? Or was it 10 million? I think it was crazy. No, it was 1 billion, sorry. 1 billion 10 years ago. And that number has not gone down. Okay.
Very good. Board members, any other comments on this item? Okay, could I have a motion to receive item 14? Okay, Mayor Post, Ken, are you, yes, thank you. All in favor? Yes. Okay, item 15, and Staff Sergeant, I just wanted to bring to your attention why this is on here. We have the false alarm reporting, and it seems odd, why would you have that in a documentation? We're trying to save the taxpayers money, and every time we get a false alarm, it is a call for service. And that call for service goes against the taxpayers of Orangeville, and we're charged for it. So we'd prefer that that didn't happen. And the list used to be significantly longer, and it's been truncated since that time. And I'm speaking to you because you're going to be the only one that's still here as Inspector Corrin leaves. And we just decided that we would leave it on here. To me, board members, it seemed a little bit longer than it had in the past. I looked through to see if there was any patterns, some sort of a theme that we wanted to bring up and say, should we be contacting these businesses and having a discussion? I honestly don't see a pattern. It feels like it's a bunch of one-offs. There is a business in the West End that seems to be constantly being hit with break-ins and whatnot, and they're on here as well. So I don't blame them for having false alarms given the situation that they're in. But I don't see what we would do with this document other than continue to review and follow up. I think it's important that we do it, but I don't see a pattern or anything that we need to do with this at this time. Everyone agrees to that. So if that's the case, Ken, do you agree? I'm sorry, I was talking to everyone. Yes. Okay. Given that, if we just have a motion to receive this document, Member McSweeney, Ken, thank you. All in favor? Yes. Okay. So that's item 15, and we're on to 16. Is the speaker arrived? Yes. Okay, great. So Leanna? Yeah. Did you want to come up to the podium here and just make sure your microphone is on? Mona, are they good to go in terms of speaking? That's great. So this is the Dufferin County Attorney and presenting on bail reform, and we certainly appreciate you being here. Guess that is my introduction at this point in time. I guess I'll turn the tables over to yourself. Is that? Oh, okay. I can see it here. Yeah, the document's up on the screen for everyone to see, and I'll turn the floor over to yourself. Thank you so much for being here.
Thank you. And I'm assuming the microphone works. Okay, I can't quite tell if whether it's on or not. Oh, close. Is that better? Okay. Thank you for having me tonight, and I send the regrets of the Attorney General who couldn't be here to deal with this. So I do have a number of slides here just to explain and break down the processes of our law of bail. So when a person is charged, obviously a police officer has the ability to decide, taking in various factors, whether that person should be released or whether they should be held for bail. If they are held for bail, from the time that they are arrested, they have to be before a justice of the peace within 24 hours. That justice of the peace does not determine guilt or innocence. Their only purpose at that point is to determine whether the accused person should remain in the community until the criminal matters have worked their way through the justice system. The presumption is that a person should be released from custody and remain out of custody prior to their trial, unless it can be shown why that should not be the case. So obviously the reason for that is because everybody's presumed innocent until proven guilty. And that's enshrined under Section 11E of the Charter. And 11E, actually what it says is that a person who is charged with an offense has a right to not be denied reasonable bail without a just cause. So the concept of reasonable bail relates to whether the person should be released, but also, if they are to be released, what are the terms that should be imposed? When deciding and dealing with the bail issue, we are guided by the principle of restraint, which requires that any conditions that are imposed on an accused person, first of all, they need to be clearly articulated. They need to be minimally in number, and they must be necessary and reasonable under the circumstances, and it must be the least onerous in the circumstances and sufficiently linked to the risk that that person poses by being out in the community. And Section 515 sub 10 of the Criminal Code guides us with respect to the grounds that we need to consider whether somebody should be released or not. The next, thank you. So the Supreme Court of Canada and the Criminal Code has set out essentially a ladder principle. And that applies to all bail hearings. And again, it doesn't just apply to what type of release somebody should get or if they should be detained, but again, it also is considered as to what conditions should be placed on them. So the concept is that a person who comes before the courts at a bail hearing stage should be released on the least restrictive measures. And if there is a concern for the safety or there's either the justice of the peace does not feel that that lowest ring of the ladder would properly secure the safety of the community, then they have to work their way up. They can't just jump to the top because of the nature of the charge. They have to work their way up. So we generally, as a Crown, bear the onus in most cases of proving why a person should be held in custody, or if we believe they should be released, at what level on that ring. We obviously have to provide evidence as to why we say that. A surety release involves a person pledging or making a promise to the court that they will supervise the accused and that they will follow the terms of their release. Often you hear people describe it as they become the jailer. So person comes into the courtroom, they're in custody, and the thought is perhaps they could be released at surety, perhaps if it's at that level of the ladder that we require to protect the community. That person becomes essentially the jailer for that accused person. The law requires that the justice of the peace must exercise restraint in the use of sureties, only ordering a surety release where it's satisfied that the least onerous option in the circumstances just will not satisfy and protect the community. The decision about whether to release or detain an accused person rests solely with the presiding justice of the peace. And it's in accordance with the unique facts of each case, the relevant legal principles and case law, and in consideration of arguments made by the prosecutor and the defense counsel. So next one. So the latter principle, I'm not sure if you can see on the print, it's kind of small, but the next slide. Oh. Okay, there we go. I know the printing is kind of small on that, but if the accused person isn't released by the police, they will be held, they'll be brought to court, and it'll be for the justice of the peace to decide, first of all, whether there should be a release order, whether it should be with or without conditions, whether it should be a detention order where that person is detained in custody until their trial is complete, or that no bail determination is made and the person's remanded. So these are the circumstances where perhaps the accused person isn't choosing to seek bail. Sometimes they have outstanding charges. They know that their chances, because you only have one chance at getting bail, and sometimes they choose to hang on until perhaps they can get a better plan in place, or they resolve some of their matters in the hopes of putting themselves in a better situation. So as I indicated, it's generally the Crown's onus, except for exceptional circumstances, to show cause why an accused person should be retained or a more onerous form of release should be imposed. Now, there are provisions within the criminal code that make it essentially a reverse onus. So that means that a person is in custody and remains in custody until they can show cause as to why they should be released. And 515 sub 6 of the criminal code sets out when an accused person will be in that reverse onus situation. The most common one is where a person is has been charged with an indictable offense and is already out on an indictable offense. So that generally is the most common kinds that we see. Another situation is where an indictable, where a person has been charged with an indictable offense alleged to have been committed in the benefit of or at the direction or in association with a criminal organization, where they're charged with an offense alleged to be a terrorism offense, where they're charged with an offense designated under the Securities of Information Act, where it is charges involving weapons trafficking or an unauthorized transfer of weapons, where they are charged with an offense where a weapon is involved, and that it is alleged that it's been committed while they are already on a prohibition to not have any firearms or weapons. There are certain serious offenses alleged to have been committed with a firearm that also comes under the reverse onus category. For instance, things like attempted murder, sexual assault with a weapon, or robbery. Where the person has committed an indictable offense where the accused is not ordinarily resident in Canada, and an offense in the commission of which violence was allegedly used, threatened, or attempted against an intimate partner. And the person has been previously convicted of a domestic or an intimate violent offense in that sense. That is fairly new. That came in under Bill C-75. So this has certainly been a good thing. Somebody who's already been convicted of a domestic style offense and finds himself again, whether it's the same partner or a different partner, it puts him in that reverse onus situation. A drug offense under the Controlled Drugs and Substances Act, which comes under sections 5 through 7, which is offenses that are punishable by imprisonment for life, which tends to be your conspiracy types of offenses, and an offense involving a fail to appear in court or a breach of their court order. So those are the situations where it would reverse the onus, and now it's for the accused to have to show why they should be released. And the standard of proof in those situations is on a balance of probabilities, not like as in a trial situation where it's beyond a reasonable doubt. And for obvious reasons, again, we go back to the standard: a person is innocent until proven guilty, and also because at that time at a bail hearing, it is allegations. Nothing is being proven at that point. They are merely allegations. So there are a set of circumstances where it comes under section, sorry, you can go to 469, which also puts an accused person in a reverse onus situation. Most common, there are a number of the ones there that in my 23 years of experience, we've never prosecuted, but your standard ones are your murder, intimidating parliament or legislature, attempting to commit any offense mentioned there except for murder. So an attempt murder does not fall under the circumstances. Any conspiracy to commit any of those offenses or accessory after the fact, for instance, murder. And in those circumstances, the person cannot be released by police at all. And as they come into our bail system, which is in the Ontario Court of Justice, that justice of the peace must detain them at that point as well. They have no power to release. The only option that that accused person has is to show cause in the Superior Court or Superior Court judge, and to show why they should be released. As much as I would love in my years of being a Crown to prosecuting alarming His Majesty, I haven't had that pleasure as of yet. So the grounds for detention, which is section 515 sub 10. In this situation, regardless of who bears the onus at a bail hearing, there are certain things that a justice of the peace must consider before deciding whether to detain or at what type of level of release they should be ordering. The first one is called the primary ground, and that is to ensure that the person charged, the accused, will attend court. So for instance, if they have a record for failing to appear in court, that's a factor that's considered. Sometimes if they're not from this jurisdiction and there's a concern, perhaps, if you have somebody who was dangerously driving and then flees from the police, then that's a factor that would be taken into consideration. The next ground is a secondary ground, and it tends to be the most common, and that is to protect the public, the victim, or prevent the commission of further offenses. And the tertiary ground is essentially to maintain the confidence in the administration of justice. And the kinds of things that a court will look at in those circumstances would be the strength of the Crown's case, the gravity of the offense, circumstances surrounding the commission of the offense, for instance, if a firearm is used, and the fact that if the accused is convicted, that they could be facing a potentially a lengthy period of imprisonment. So those are the kinds of factors that a court has to consider when deciding whether to detain or not. And each of these grounds is independent, and there is no specific order as to the hierarchy of them. And if the accused is released, these same factors are things that need to be considered by the court in deciding what terms to also impose on an accused person. So as Crowns, we are governed by our Crown Prosecution Manual. And that is a manual which contains information and directions for Crowns on criminal process, role of the Crowns in the criminal justice system, and any directions from the Attorney General to prosecutors on how to handle certain things. And there is obviously a section on bails. The directive affirms that accused persons will presumptively not be detained pending trial, and that the default position is an unconditional release. It also directs Crowns where if they believe that the release of the accused person would jeopardize the safety of the or security of a victim or the public, and such risks cannot be appropriately mitigated by some form of release with conditions, then we must seek detention. So we have to consider many of the same things that a court would consider. And if we feel that we can release somebody, depending on what the evidence is and working our way up the ladder, we can propose a form of release to the court. It is the court who can endorse it or choose not to. And then in the situation where we are not proposing release, that we are seeking either to show cause because it is our onus, or seeking that the accused party show cause why they should be released, then an actual hearing has to occur, and then the justice of the peace follows those same guidelines. So there are some bail directives that and special considerations in the Crown Prosecution Manual. And for instance, one of them is intimate partner violence. So obviously we are very cognizant of the fact that there's a potential increased risk of harm in these types of cases, and that we should consider seeking detention where it's necessary for the safety and the security of the victim or the public. We also are quite cognizant of the fact that when a victim comes forward in an intimate partner situation to allege that violence has occurred, that most likely it has happened several times before they even go to the police. And we have to look for those factors in the file that show any kind of pattern of assaultive or controlling behavior before we decide whether or not we can propose any form of release. And obviously, violence comes in different ways. It's not just physical assault, but may include emotional, psychological, sexual abuse, and anything that is intended to induce any kind of fear, humiliation, or powerlessness. Just like in any case that comes before us, whether it's an intimate partner violence type case or not, we always have to assess our case and the strength of our case. And our positions may change depending on that. And we have to be sensitive to the needs of the victim and to the dynamics that exist in families where a partner is allegedly abused. Another specific directive has to deal with firearms. And the directive does indicate that if there is a firearm case in the bail court, that we must seek detention absent exceptional circumstances. If those exceptional circumstances do exist, a Crown attorney must seek, assistant Crown must seek the approval of their Crown attorney before agreeing to release somebody, or a designate of the Crown attorney. Another area is vulnerable populations. So we have to recognize the circumstances of vulnerable and disadvantaged accused parties, including racialized populations, the homeless people, the poor, and those suffering from mental illness or addictions. That is because often they don't have access to accommodation and resources that other people might, and the supports that exist in the community for them. So pretrial detention should never be used as a substitute for mental health or other social measures. And so we have to balance and factor in that as well when making decisions. And the last special consideration for bails under our Crown Prosecution Manual is Indigenous accused persons. And we have to consider, because often, many times, they are quite a distance from court, and their remoteness of their communities often create barriers for them in being able to access bail. And in these circumstances, seeking the detention of an Indigenous accused person should remain an exceptional measure as well, unless, again, the release would jeopardize the safety of and security of the victim or the public. Sure. Thank you. So there are some dedicated bail resources that have come into place recently. And the most recent one is the Intensive Serious Violent Crime Bail Teams. And this came about in April of this year, where the Ontario government announced a $112 million investment over 3 years to ensure that high risk and repeat violent offenders comply with their bail conditions. As part of this, the Ministry of the Attorney General will invest $26 million over 3 years to establish these intensive serious violent crime bail teams. So the work of this team will expand and broaden the work of the existing intensive firearm bail support teams that are in place in Toronto, Peel, and East Region, and will provide province-wide coverage as needed. So these teams are there. They're dedicated prosecutors and business professionals from across the criminal law division who will be trained and have expertise in preparing the best case possible to put forth in a bail matter involving serious and violent crimes, and to conduct these complex and lengthy hearings. I can advise that for Orangeville, we won't have a designated Crown as a part of this, but the same group will assist in helping us to make sure that the best case that we can put will be prepared for the bail hearings. The funding will also increase the capacity of the courts to hear bail matters. This will ensure that our courts have the resources they need to hear them more quickly and more efficiently. And they will work in tandem with police services and bail compliance units, and will have the resources to put the best evidence forward. So what will those resources consist of? First of all, they're going to have Crown bail vetters. So these are dedicated prosecutors who give focused and intensive attention to bail files with a view to streamlining the bail process and reducing adjournments and encouraging early resolution of charges. Since the province-wide rollout in November of 2021, which was the backlog reduction strategy, Crown bail vetters have been able to increase speedy resolutions by reviewing accused profiles at the bail stage. Sometimes they will assist in reaching global resolutions if the person has multiple outstanding files. Before the case management and other complex and work-intensive processes must be undertaken. So this having a good solid package to put forth not only perhaps brings the message home to them, perhaps that bail will be difficult to achieve, but it also encourages and stimulates that discussion to try and resolve things and save the court time down the road. Bail verification and supervision program, Indigenous bail verification and supervision program. These programs serve accused persons who do not present a risk to the community and who would otherwise not be released due to barriers such as lack of finances, sureties, social ties, and other factors. And they're supported through the system if they are to be released, and assisting them in attending court. There's also the bail bed program, an Indigenous bail bed program, and these programs provide community-based residential supervision for accused adults who would likely otherwise be held in custody, but who can be safely released with additional supports and higher levels of supervision. There's the Justice Centre pilots, and these are 4 pilots that are located in Kenora, Toronto Northwest, Toronto Downtown East, and London. And they are designated to help break the cycle of reoffending, including violent reoffending and reduce bail and remand populations. The Toronto Northwest Justice Centre deals with the most serious criminality, focusing on youth and community violence as well. And community justice coordinators, these are dedicated resources and prioritized courthouses that aim to reduce lower severity reoffending by improving personal outcomes. They would create individualized plans and connect, again, accused parties to supports in the community to assist them. And it uses a needs-based approach where accused persons improve their own circumstances in the hope that, you won't see them back before the courts again. So there's Bill C-48, which on January 13th, 2023, all 13 premiers sent a letter to the Prime Minister calling for immediate action to strengthen the Canadian bail system. The call to action was answered, and on Tuesday, May 16th, 2023, the federal government tabled Bill C-48, which sets out proposed amendments to the criminal code. If passed, the proposed legislation will bring meaningful and much needed changes to our bail system. Right now, it's at the second reading. The proposed amendments include such things as a new reverse onus provision for accused persons charged with serious offenses involving violence and the use of a weapon, where the accused person has previously been convicted of an offense of the same criteria within the past 5 years. And both of those offenses must be punishable by 10 years of imprisonment or more. Now, certainly somebody's prior record is always something that was considered at bail, but it was never necessarily putting them in a reverse onus just because they had a prior conviction. So on these ones where firearms are involved and they meet those criteria, it now puts them in that reverse onus, having to show cause why they should be out of custody. There's now an expansion, there would be an expansion of the existing reverse onus provisions for firearms, including Section 95, which is an unlawful possession of a loaded, prohibited, or restricted firearm, as well as for Section 98, breaking and entering to steal a firearm, and 98.1, which is a robbery to steal a firearm, and Section 102, which is making an automatic firearm. So those would automatically become reverse onus situations. The proposal also has an expansion of the current intimate partner violence reverse onus provision to include those accused persons who were discharged previously from a intimate partner violent offense. So some people who come before the court with an intimate violence partner violent offense may be found guilty, but may not get a conviction. So it may be what they get a conditional discharge or an absolute discharge. And so the plan is to change that. So just because they don't have conviction on their record, it can still be a reverse onus situation in those circumstances. There's also going to be a clarification of the meaning of a prohibition order. The reverse onus provision for those charged with offenses involving firearms and other weapons where they are subject of a prohibition order now expressly includes the court judicial interim release order that imposes a no weapon condition. So prior, if you were prohibited after a finding of guilt from possessing or owning any firearms or weapons, then that was a reverse onus, but it did not capture if the person was on a form of release from bail on a separate incident with a term to not possess any firearms, and then gets charged subsequently with another firearms offense. So they're capturing that in these new proposals as well. And lastly, a requirement that courts consider whether an accused party has a history of convictions involving violence when making a bail order, and to state on a record that the safety and security of the community was considered when making a bail order. So those are the proposed changes that we hope will make it past the second reading and come to fruition. So if you have any questions, I know I didn't specifically set out the ladder in each one. I'm happy to go through that if it's something that you're interested in as to the types of releases that are available. But subject to any questions you may have, that's the presentation.
Board members, any comments or questions? And maybe I'll just kick off if I could. So maybe it's just a comment. And I think, first of all, thank you for being here. And secondly, I'm so thrilled to see that the bail reform is encouraging early resolutions. Like, I think that's really one of the key items of the whole process, is to make sure that A, we're safe, but B, the process is moving forward. And I was listening in detail to what you were saying, and I think I wouldn't have the expertise that you would, Member McSweeney, but it feels like you're going to accomplish this, and the tone in your voice gave me the sense that you felt that these changes were going to enable you and your team to be able to do that. Is that kind of the way that putting words in your mouth, or?
No, I think it is the realities of a bail court. You're getting the file very shortly before the bail happens. You have limited time in preparing and reviewing. And yes, I can access some information, but not everything. These teams that they were going to be putting together will be able to be dedicated just to that. They will have the time to dig further into files and get even further information to, again, put our best foot forward in showing either A, somebody should be detained, or at the very least should not be released except for the most restrictive type of releases. Yes.
Good. Member McSweeney, do you want to speak to this?
I don't really have a question, but just sort of a comment, just to remind everybody that it's interesting, the sequencing here, because the Orangeville Police Services Board was invited by a number of other police services board, I think led by Guelph, earlier this year to support their submissions that they made on bail reform, which we did. Things seem to happen really rapidly right after that. I don't claim that our input was the impetus for that, but it is interesting. We wrote to everybody on a long list, including the Minister Downey and his federal counterpart, the AG of Canada. We got a long letter back from the AG of Canada, which is an interesting read. I just reviewed it again, talking about bail reform generally, and that in fact Bill C-48 had been tabled in May. So things from our perspective have really happened quite quickly. I know that that doesn't often happen, and it's just an illusion, but a lot of thought went into this in terms of particularly the reverse onus aspects of making it more difficult in a measured and reasonable way for individuals that commit the kinds of crimes that would endanger the community from being easily released and recommitting those crimes. So I do commend the initiative. Thank you.
Yes, and no doubt that your work assisted, but sadly, I think the newspaper reports and the constant news reports about police officers killed in the line of duty, often been out on bail already on violence. Not surprisingly, led to this initiative and pushing this forward.
Board members, any further comments? No? Ken, I just want to make sure, no? Inspector Corn, did you want to speak to this item at all, or you good? Okay. Thank you so much for taking your time out to come here today. And it was just great to meet you, and really appreciate the information that you gave to us.
Thank you for having me, and have a wonderful day.
Okay, thank you. Board members and OPP, I don't know that this is going to save us a ton of time, but my sense is that our OPP friends have to leave. If board members could indulge me, I wonder if we skip down to, and if anybody else has a better thought, I think the only thing we really need to talk to with the OPP that's left is item 20, which is the school resource officer. We did cover it in the in-camera session. Would anybody have an objection if we move forward to item 20 and allowed these fine people to leave the meeting? Okay, so if we're going to do that, so item 20 is the school resource officer. It was discussed under 12.2 of the June 21st, 2023 regular in-camera session meeting. And really, it was just a rise and report item. I think we covered a large portion of this in item 6.7, and Inspector Corn offered his thoughts. Just want to make sure that we've covered this in open as well. Board members, does anybody want to offer anything further on this item, or how do you want to handle this? Looking at you, you look like you want to speak to this.
No, I'm delighted that we're dealing with it in public. I think we should explain to the public the progress that has been made.
On the school resource officer? Okay.
Maybe that's an Inspector Corn discussion.
I was going to say, Inspector Corn, did you want to can you reiterate the comments? So the reason that this is important is just we covered it off and closed. The board doesn't want to cover off any items, or doesn't want to leave anything enclosed that we can cover off and open, and that's why we're kind of regurgitating the items. So I'm just hoping you could offer your perspective.
Certainly. Yeah, we identified the need to have a school resource officer and have now identified Constable Pitton as that person. So she is settling in. She's only been in the role for, I believe, 2 weeks now. And once the conclusion of the plow match takes place, next week she is meeting along with some other detachment representatives with the school board so that we can determine what the needs are, what our role will be, what the expectations are. So that is still in its infancy, but we're very optimistic that it will certainly fill a gap.
That's great. Okay. Board members, any further questions?
Mr. Chair, just through the comment made and closed by Member Craker, I think the board intends to have Officer Putin. Is it Putton?
Pitton. Yes.
Pitton.
Yes.
Not Putin.
Not Putin. No, slip of the tongue. At a future public meeting and to explain the progress and her experience.
That's great. Okay. Thank you very much to you both. So nice to see you. Thank you for being here. Congratulations on your promotion. We look forward to working with you, and safe drive to Shelburne. We do have speed traps on the way to Shelburne, so if watch out for those as you're on your way up there. And by the way, we're much nicer than they are, so Yeah, please pass that on to the board. Okay, so board members, let's move back to item 17 and we'll finish this off if we could. So item 17 is the approval of the public session meeting minutes from June 21st, 2023. It's the regular public session. Could I have a motion to approve those meeting minutes? Member Post, Member McSweeney, all in favor? Oh, actually, excuse me, any questions? I apologize, I rushed that. No, seeing that. All in favor, thank you. Great, so that motion passes. Item 18 is school bus safety. This has been an ongoing item for quite some time. The way that we had left this was that our friends to the south in Brampton had researched, maybe actually is it Caledon? It's Peel, excuse me. Oh, I was close. Yeah, Peel. So had researched this and the idea of having the school buses enhanced with this opportunity, and unfortunately it is not cost neutral. So it was passed on by the area. And Member McSweeney, my understanding is you want to speak to this a little bit further here in this meeting.
Yeah, I don't have anything much to add. I think you're right that regionally it doesn't appear to have received much traction. I think maybe just for our own peace of mind, we should revisit it annually or periodically and just have another look at it. I think what it needs is a regional champion to, coordinate some cost-efficient way of bringing a program to fruition. But I don't think now is the time.
Whenever we have these discussions, I always think about the other board that I sit on, and that's council. And I think council would say the exact same thing that you just said. So we've circled around that as well. Mayor Post, would you agree with that, or do you think it's worthwhile bringing to council again?
The only addition that I wanted to add to the conversation is that I think for this to be a successful component, it really needs to have school board buy-in. And unfortunately, at this point, with the conversations that have happened through Dufferin County, we do have several different school bus providers. We've got there's a more rural component, there's an urban component. Our school board covers a huge geography, and really for it to be successful, the school board needs to be willing to work with a community champion, I think, to bring this forward. So I think ongoing discussion with the school board would be a great idea. But I do think that we need to shelf it for a little bit. I don't think we have the time or resources right now to have a champion dedicated to it. But I think that perhaps an ongoing conversation with the school board or our school board trustee would be definitely appropriate at this point.
Thank you for that. So we are working at having our school board trustee come to this forum and have a discussion with us. And maybe that's just a secondary issue that we add to that discussion.
I think that would be a great thing is when we can get them to come to, and again, we have several school board trustees within this area, within Dufferin County. So it would be great if our local school board trustee could take that back to a school board meeting and see if there's flavor and desire to visit it at their level.
So when I have him scheduled, I'll mention that those are the two items that we'd like him to
Mr. Chair, just a final comment. Members will recall that some meetings ago, we received a delegation from the community that were quite concerned about a particular street intersection where traffic was bypassing stopped school buses on both sides.
Yeah.
And parents were out taking photos and standing in the street, being very proactive in trying to dissuade drivers about passing the school buses and the like, which is obviously a dangerous situation. So I think we should continue to look at it going forward for that reason as well.
Okay. So I think we're at the point for now. We'll receive that. I've had my follow-ups about the school board trustee, but I don't think we need a motion. It's a separate issue. So I'll just ask that the board receive this item at this time. Can we have a motion to do that? Mayor Post. Ken, thank you, sir. All in favor? Yes. Okay. And so item 19 is about board vacancy, and you can tell if you're watching this that we are down a board member at this time, and that is because of the resignation of Mary Rose. And just ever so briefly, what I did, board members behind the scene, is a little bit embarrassing now that we know how the board composition is working. And that is I did contact that agency. There was a personnel change at the agency. So the relationship that I had, I wasn't able to utilize. We had a new person that came in. That person gave me a response that I was not happy with, because I thought they were really dragging their feet on getting it done. I escalated it. Was sort of forceful in my position, and the other end went blank. And now I understand why they did. And that is, it was already done. We hadn't been informed. And the already done piece is the boards in Dufferin County have been shrunk from 8 to 4. And this board will move forward with 1 provincial appointee, 2 members of council, and 3 members of the community. So at this point, what that means is Mayor Post and I will be approaching the town, and we will be asking that a advertisement goes out to the community, asking for 2 new public members to come forward and join our board. And ideally, they're members of the Orangeville community and have a passion for helping with our police and the administration of it. So it should be an interesting time, and that will come out very quickly, because we're anxious to have new individuals on this board. So board members, I leave it with you. Do you have any further comments or questions, or do you think I didn't describe it properly? Very good. Seeing no comments, I'll ask that we receive that report from myself. Ken, Ian, thank you. All in favor? Yes. Okay. So that we've already covered off item 21, or item 20, excuse me. So that brings us to item 21, which is question period. We do have some gallery members. Any questions at this time? Seeing none? No? Okay. And we don't, as noted in agenda item, so the presentations, I guess we did have a presentation, but we don't have any more presentations at this time. No delegations. Nor correspondence. However, we do have reports, and that report is the Orangeville Police Service Records Freedom of Information Act. It's an update, and it's in the documentation for anyone to see. And that motion, I would ask that if there's any commentary, that's great, but I think we simply would receive that report from the town clerks. So any discussion on that? Seeing none, I have a motion to receive this report. Mayor Post. Ken, thank you. All in favor? Yes. Okay. Under new business, any new business items? Member McSweeney, you wanted to speak to one item?
Yeah, well, no, at the opening of the meeting, when we were looking at the agenda, I indicated I had a new business item to deal with, but I don't think we don't need to deal with it anymore, because we dealt with it under Zone 5 and under the discussion about the governance. So I think we're good.
That's great. Okay. Anyone else before we call for adjournment? Very good. So at this time, we're at adjournment. Would anyone like to make that motion? Member McSweeney, Ken, all in favor? Yes. Okay, very good. Thank you very much, everyone. Appreciate this, and we'll close off this meeting at 5:58. Good night, everyone.